Good morning, everyone. Welcome back to Business Law 1. Today we're looking at Chapter 31, which is a basic introduction to property, and we're looking mainly at personal property and fixtures. So I want us to understand, in terms of the objectives for this chapter, the difference between personal property and other types of property. We'll talk about how rights in personal property can be acquired and maintained. And then we'll look at how some kinds of personal property can become part of real property, meaning like land or like structures, through this process that's referred to as becoming a fixture. So that's the overall kind of like focus for this chapter. Anyway, when we think of personal property rights, that consists either whole or partial ownership rights in things that are tangible and movable, as well as intangible goods. So when you think of like a car, a computer, a desk, furniture, those would be tangible examples. Intangible could be a trademark, a copyright, a patent. So it covers both tangible and intangible. And remember, when you own property, you have the right to possess it, to use it, to enjoy it, dispose of it, and that's entirely up to you as being the owner of property. Usually where things get complicated is when you have multiple owners in property, because then it can be a little kind of complicated, when there's maybe conflicting ideas about what to do with property. But for you, let's say if you own a tablet or a laptop and it's just yours, you don't share it with anybody. It doesn't belong to, you don't co-own it with a friend or a spouse or a mate or something. For you, it's like you can use it. When you're done with it, you can recycle it, you can trade it in, you can chuck it, and you can dispose of it, hopefully in a safe way, not just in a landfill. But that's your right as an owner in that particular property. So as we kind of go through this, just make sure you kind of understand that. When we talk about personal property, ways in which you acquire personal property is by purchase. So you actually buy something. You buy a laptop, you buy a desk, whichever, and you own it at that point. It could be by gift. So maybe a friend gives you something, and so we've talked about gifting in here, but as soon as you get it, then it's yours at that point if it's a true gift transaction. By occupation or possession, some statutes provide for that, by if you kind of like happen to discover or find something, and we'll talk a little bit more about this in a few minutes. I have listed here on the website. I won't show it to you now, but I usually do it when I have face-to-face classes. There's a website. Every state has a comparable version of this. But in Florida, it's called fltreasurehunt.org. And essentially, when property is abandoned, especially if it's like, let's say, financial in nature. So, let's say it's a bank account, maybe it's a security deposit with, landlord, or maybe a utilities company. And let's say you move and you forget that you had that account, because it does happen. It's rare, but it does happen. These companies just don't keep that. It's like free money. They have to do their best efforts to try and find you. If they cannot find you, then they transfer those assets to the state. And the state then, keeps a public record, and that's what this website is. And if you go to fltreasurehunt.org, you punch in like your name, and it'll ask you maybe some questions, and it'll scan and look and see if there's any property that belongs to you. And I've had students tell me that, they had maybe a utility deposit that they forgot about, years ago. And, it's like, well, maybe it's, what's whatever, $100, $200, whatever. It could be, I had a student years ago that worked for that restaurant Bennigan's that went out of business. But as part of a settlement, there was money that was like, that Bennigan's had paid to all their employees as part of like a severance in the bankruptcy process, and the employee didn't know about it. But this sum of money was in an account at fltreasurehunt.org because the bankruptcy trustee could not find a certain number of former employees. So it's worth your while to take 5 minutes and just kind of punch in to see if you have any unclaimed property. If you have lived in other states, just Google that state and unclaimed property. So let's say you used to live in Tennessee. You would type in Tennessee unclaimed property and hit enter or search. and whatever their website version is, it may be tntreasurehunt.org. I don't know for Tennessee, or it's maybe something different, but every state operates a website like this. Most of the unclaimed property are financial in nature, so it's accounts, but if they also do have like storage facilities where it's actual physical property, and so it could be that as well. But if you do find property that you think belongs to you, it'll ask you more detailed questions, and then a human will then review your request, and they'll make a determination, are you the actual person or not? And then there may be follow-up questions if needed, or within a few weeks you might just get a check in the mail. So it's a fairly straightforward process, and like I said, every state does this. So wherever you used to live, you can just do a Google search, punch in the information that's asked, and you'll see, is there money out there or not that belongs to you. The King is Dead is a case, and this was a Tennessee case, and I'll kind of just quickly go through this. Elvis Presley, well-known pop musician from decades ago, and in the near the end of the 70s, he was scheduled to perform a concert in Memphis, and this was the concert that was never performed because he died. And there were a lot of ticket holders. I mean, it was Elvis, he would usually sell out in these venues. And so the venue offered to all ticket holders a 100% full refund. Just bring in your ticket, we'll give you your money back, and we're sorry about it's tragic what happened. There were several $100,000 in tickets that were not returned, and so you had all these ticket holders who decided to hold on to their tickets. And I usually will ask, if it's a face-to-face environment, I'll talk with students, and usually reasons why people would not want to turn their ticket in for a refund. And it's usually it's memorabilia, it's like the concert that never was, maybe they're thinking it might be worth something someday. Different reasons why people don't want to return a ticket. The problem though is that, I mean, there's money that's floating around now out there in an account that the venue is kind of like, has access to, and they can't really like claim those funds normally, because it's like, well, I mean, the concert never happened. The estate of Elvis Presley years later tried to claim it, saying that, well, if no one else is going to claim this property, and if the ticket holders are not going to seek a refund, then it should belong to us. And I think the theory that they were thinking is that, even though those ticket holders didn't see the concert, they're still getting something of an intangible value, because it's a connection to Elvis, the performer. And so they actually they sued the city of Memphis, because that was the overall kind of like entity that managed this venue. And so the city of Memphis, they as part of like trying to kind of like respond to this lawsuit, because we're now talking about hundreds of thousands of dollars that the estate's trying to get hold of out of this government account. And in Tennessee, they had passed years before what was called a Uniform Disposition of Unclaimed Property Act, and essentially, this state law basically kind of provided a framework or a pathway to follow to deal with unclaimed property in a unique situation like this. What ultimately ended up happening was that it ended up belonging to the venue, and so the city of Memphis was able to kind of retain those funds then and absorb them, just as if they had earned it by Elvis completing the concert back in 1977. So it does kind of reinforce the idea that when it comes to money, we don't like the idea of just like money being like abandoned. The law doesn't seem to settle well with that. We want to figure out a way to get lost money back to its rightful owner or home, so to speak. That really is a priority. You think of like, if you had like, let's say $100 in cash, most people don't just like throw it in a garbage can. That would not be normal. We don't like the idea of abandoned property like that. You can throw away other things, but when it comes to money, we don't usually think of that as like that's an option necessarily. When we talk about gifting, there's two categories of gifting. There's inter vivos and causa mortis. Inter vivos is a Latin phrase which means between living entities. And so if someone has donative intent, like I want to give whoever, another person or an organization, a gift of whatever. It could be cash, it could be a physical good of some kind, whatever it is. So that's the intent. You have to also couple with that delivery. Now, delivery can be actual or it could be constructive. So actual is like, here, I'm giving you $1,000 and I'm putting it in your hands. It's like I had the intent and I actually delivered it. Constructive is, maybe I get a money order and I get $1,000 money order and I mail it to you. And, maybe, mail takes 2-3 days. And so you haven't received it yet, but it's constructively yours because I made it out to you and I put it in a mailbox with a stamp on it. So that would be like the constructive example. You don't have it yet, but I mean, you're going to get it. If the donor dies before the gift is complete with inter vivos, then it fails. So maybe I call you and I say, hey, I want to give you $1,000, so I'll swing by your place after work. And so on the way to, drop off the $1,000 wherever you are located, I get hit by a bus and I die. Well, it doesn't matter that I had the intent. Delivery was never effectuated, actual or constructive. Causa mortis, well, one more thing with inter vivos. Once the gift is completed, it's a done deal. You don't ask for it back. I mean, you could. That's, it's not very, it's kind of an awkward conversation. But legally, you have no ability to reclaim a gift once you have completed that transaction. It's gone. Causa mortis is a little different. This is considered a conditional gift. So again, it's the same thing. You got to have donative intent and you got to have that delivery, actual or constructive. But you're giving the gift in contemplation that you are going to die. Maybe you're going in for a risky surgery. Maybe you got bad news on a test result, and whatever. You can only imagine the different situations that could arise. And sometimes in that situation, people are contemplative and they're like, well, I'd rather give things to people while I'm alive so that I can kind of see their reaction. Obviously you could just wait till you die and then the will, the administrator of the will take care of that stuff. But some people want to just give things before they pass. Let's say that, you distribute whatever, you give out these gifts because you think you got 6 months to live. And let's say that, a miracle happens, they come up with a cure for, whatever, or you survive the surgery, whatever it is. And you realize, wow, I would like my car back, or I need this money back, or whatever. Because it was made in contemplation of death, you can ask for a causa mortis gift back, and the law will support you in getting that property back. So that's really the big difference between inter vivos and causa mortis. Inter vivos, once it's a completed gift, it's gone forever. Causa mortis, if you survive, you can expect to get that property back. I usually, and again, this is a more of an interesting conversation that, in a face-to-face environment, when I try and have students understand the difference between lost versus abandoned property. Lost property, the idea with lost is that, upon discovery that something is lost, you want it back. So maybe you lost an earring, or, I don't know, you left something in a public space. I don't know, whatever it could be. And so, as soon as you figure out, oh, wow, this is missing. And if you can somehow connect the dots to where you last had it, you want to go back and be able to reclaim it. So, I have the rule here in Florida, and I won't read you the rule, but, the theory is if you discover something that's of value, you return it to whoever is the managing authority where it was located. So if you're at one of the Valencia campuses, and let's say that in a parking lot you find, let's say a tennis bracelet, a diamond tennis bracelet, and it's valuable, and that someone isn't just going to say, I'm tired of having this diamond bracelet, and then throw it on the ground. That's not what some people normally do. So you go to the security office and you turn it in, and then they will, usually will post, like lost and found, on their website, or if you show up in person, and try and get it back to the rightful owner. That's the theory. Now we know the reality. The reality is someone might see it on the ground, pick it up, put it in their pocket, and just never be seen again. So I get the reality versus the theory, but this is the theory. Contrasting lost property with abandoned property. Abandoned property, there is no way you want that property back. And I usually, what I like to ask students is to try and figure out, well, how do you know when you discover property, is it lost or is it abandoned? Because I mean, sometimes it's very situational specific. Normally, and the law usually kind of lumps these types of examples in the same way. If it's in garbage or associated or attached to garbage, we're going to say that it's abandoned. So I remember when I was an undergrad, I lived in an apartment community, and I'm sure you guys had the similar experiences where, at the beginning or the end of the month, as people are moving in or moving out, sometimes people will put things next to the garbage area. And it could be a piece of furniture, it could be an old TV set, whatever. And they just don't want to move it, or they're done with it, or whatever. And, everybody knows, it's like whoever grabs that first, it's yours then at that point. It's not lost. You don't put things in garbage or next to garbage by mistake. And if you do, well, we're sorry, but it's garbage at that point. And so whoever wants to grab it or pick it up first, they are then the owner to the rest of the world, even the person who put it there. Same thing if you live in neighborhoods on garbage day. Sometimes you'll see like an old couch or an old bed or something, TV out on the curbside, and next to whatever the garbage containers are. Same thing, if you can get to it before the garbage company and pick it up and put it in your vehicle, it's yours at that point, whatever it is. So there's no question that is abandoned property. Anything else, it's very, very, we're going to kind of say, well, it's like, is this something that's of value? And, if it's, again, like that diamond tennis bracelet in a parking lot, that's not going to be considered abandoned property. That's not something normal that people would do. The Not an Ordinary Bank was a really interesting case years ago in Selma, Iowa. There was this elderly couple, and they had an unusual habit of saving their money. Instead of banks, they put their money in jars and buried it in the backyard, and didn't tell anybody that they did this. And so years pass, they die, and the family members didn't want the property because it was an old rundown house, and they didn't really want to pay the back taxes that were owed on it. So they didn't claim it. And so the property went up for auction, and the local church purchased the land. They wanted the land, they didn't want the old house. So they tore the house down, and while the earth movers were doing their thing, they start discovering these glass jars, and they look at them and they realize they're stuffed full of cash. And at the end of the day, they kind of carefully go through all the ground, all searching for more containers, and they find about $25,000 worth of cash and coins. Selma, if any of you have ever, I doubt many of you have been through that town, but it's a very, very small town. And so people talk. And so family members of the elderly couple showed up and said, okay, we'll take our money. And the church was like, you guys didn't claim this property. We bought it. We own it. And we, whatever's in the ground is ours. If it's money or oil or, diamonds or whatever, it's ours. And so a lawsuit erupted. The family members sued the church for the money that was found there. And the legal question in this case is, was that money lost or is it abandoned? If it's abandoned, then it belongs to the church. If it's lost, it belongs to the family. That was the whole focus of the case. Fascinating case. The judge at the end of the day, again, we don't like the idea of money just being like, abandoned, and so the judge really felt that the fact that the elderly couple preserve the currency in jars was evidence that they wanted to maybe go back one day to claim it. And that could also include giving it to family members. And so it was deemed to be lost property, not abandoned. And the church then had to give the money to the family members. So, again, it's a very unusual example, but it's a great case to highlight the difference between lost versus abandoned property. Now, if there was other things underground on that property, let's say there was like an oil well, like oil reserves or diamonds or gold or, something that is attached to the land, and the family members would have no right to that. That would truly belong to the church then at that point. But here it's, the elderly couple, they just deposited the money in the ground in that unique way. So a couple of quick things as we wrap up this chapter. When we're talking about rights and property, if it's held by one person, that usually is referred to as it's being held in severalty, which I know is kind of an unusual way. You think of several as being more than one, but severalty is owned by one. When you have two or more individuals own property, so whether it could be a spouse, family member, whoever that a partnership in a business. There's different forms of co-tenancy. The four general categories nationwide. You have tenancy in common, you have joint tenancy, tenancy by entirety, and community property. So those are the four broad categories. I only really discuss the joint tenancy because that's the Florida rule. And so this is where you have ownership by two or more persons. Absent an agreement to the contrary, normally with joint tenancy, there's what is called right of survivorship. So if one person dies, then whatever that property is, if there's just one other survivor, they get all the interest in that particular piece of property. So let's say you and a friend buy an RV, a recreational vehicle, a motorhome, and because you like to go camping. And so you and a friend buy this, and let's say it's 50-50, and your friend, years later, the friend dies, even though on the title and the registration, it's both your names, you have right of survivorship, then you would claim the entire ownership then of that motorhome if the friend dies. If you have an agreement that says otherwise, then you would follow the agreement. This is in the absence of an agreement that specifies something different. So, again, just kind of understand it. Married couples, it's the same thing. When one person dies in a marriage, the surviving spouse in Florida, joint tenancy, gets all that property put in their name at that point. Debts are something different. It depends if it's a community or a marriage debt or if it's an individual debt. If a marriage, let's say someone dies in a marriage and let's say they had their own personal credit cards, technically that dies with that person. It would have to be some sort of an account or obligation that belongs to both partners in the marriage for that debt to continue, even though one person had died. Let's see, fixtures, and this is the last slide that I'll show you. So a fixture is essentially when personal property becomes attached or associated with real property in such a way that it becomes part of the real property. So courts look at the method of attachment, how the property is adapted to the real property, and also the intent of the original persons. There's different tests that the court utilizes. There's an annexation, adaptation, and intent. But it really does depend. I think the biggest thing is the intent of the person, and then how difficult is it to remove that personal property from the real property. If it's going to cause damage to the structure, we're just going to say it's part of the real property then at that point. So think of like I've done this before in places like in my apartment when I was an undergrad. I put up on the wall some shelving, so I screwed into the wall, for the brackets, and I hung shelving so that I could, put up like some bookcase. Obviously I can unscrew all that, which I did, and you put some spackle on the wall, you cover up with paint, and so it's like it was never there. So obviously that was personal property, that shelving. It was attached to real property, but I didn't have the intent to leave it there after I left, and it didn't destroy the wall when I took it down. So that would not be a fixture. Let's say I have a friend years ago, he was a cabinet maker, and so he was really skilled at putting in like kitchen cabinets. And so, when you put in kitchen cabinets in a kitchen, obviously those cabinets are personal property, and you attach them or affix them to the wall, it's going to be hard to remove those without doing some damage to the structure in the kitchen area, you know, or wherever you put those cabinets. And so that most likely is going to be deemed a fixture at that point. You know, you don't really put cabinets in with the idea that when I leave here, I'm going to take them with me. That's not really normal. So like cabinets would be a more permanent type thing. I give some examples there. It really is, it depends. Landscaping, you know, the longer it's in the ground and the more mature it becomes, then it's going to become part of the real property. But, you know, you could imagine if it's like maybe some small flowers that you plant, you could certainly transplant them without damaging the ground. So, you know, again, it does kind of depend. Everything really hinges on what is the intent and what is the level of damage that is going to be caused by the removal of that particular property. So anyway, as you have questions, please feel free to message me, call, text, or email me anytime, and I'll be more than happy to get back with you as soon as I can. But have a good, safe, and productive rest of the week. Thank you all again for everything. Bye-bye.